Okay, so I think we are headed now to our first afternoon panel, which is freedom of speech and religion. So following up on some of what was just discussed at our keynote speech for lunch. This panel is going to be moderated by Alan Morrison, who is the Lerner Family Associate Dean for Public Interest and Public Service at the George Washington University Law School, where he teaches civil procedure and constitutional law. His work related to this conference focuses on the power of the federal and state governments to ban, authorize, or regulate some or all aspects of abortion.
Did we not do something?
So they didn't catch that.
Oh, that's all right. They know who I am.
Yeah.
All right, so I'm going to introduce our panel in alphabetical order. First is Laura Herscher, who is a genetic counselor and director of the student research at the Joan H. Marks Graduate Program in Human Genetics at Sarah Lawrence College. Her research focuses on ethical, legal, and social issues in genome medicine. She's written on these topics for such publications as Scientific American, The Nation, The New York Times. Laura is also a host of The Beagle Has Landed, a podcast for clinical genomics community. Next is Radhika Rao. She's a professor of law and Henry Samp Lillian Hastings Research Chair at UC San Francisco. After graduating from Harvard Law School, she clerked for Justices Harry Blackmun and Thurgood Marshall. Adam Seif is a First Amendment constitutional litigator at Davis Wright Tremaine, where he represents internet, media, and technology clients in matters involving the regulation of protected expression, as well as nonprofit organizations in pro bono constitutional rights, voting rights, civil rights, impact litigation. He serves as outside counsel to Mayday Health, a nonprofit education organization founded after Dobbs to share information about access to reproductive health services in all 50 states. Rabbi Barry Silver is the founder of Cosmic Judaism, which unites religion and science and was inspired by visionaries such as Albert Einstein and Carl Sagan. Barry is a self-described rabbi rouser, that's his term, civil rights attorney, singer, songwriter, motivational speaker, basketball coach, and activist who has led rallies and filed lawsuits to advance many causes such as the environment, gun control, abortion rights, animal welfare, religious freedom, and other issues. My colleague Sonia Suter is the founding director of the Health Law Institute at George Washington University Law School. A former genetic counselor, she has published widely on issues at the intersection of law, medicine, genetics, and bioethics, with a particular focus on reproductive rights and justice and emerging reproductive technologies. Okay, so this panel is divided into two parts: freedom of religion and religious freedom issues and free speech issues, both under the First Amendment. We'll try to keep the level of legal discussion at a level that suits everybody in the room here. And having said that, now I want to divide the freedom of the religious aspect into two parts, the Establishment Clause and the Free Exercise Clause. Basically, the Establishment Clause tells the government what it can't do, and the Free Exercise Clause tells people what they have the right to do. But we're going to begin with the Establishment Clause. And Radhika, why don't you begin telling us how the Establishment Clause fits into challenges to the abortion laws that we have on the books?
Thank you so much. And I just wanted to thank again the organizers for this fabulous conference. It's been an amazing second day as well. So Jennifer teed up the issues, thank you, for us very beautifully, and really suggested the analogies between the arguments on the religion side. But I'm thinking that there are actually some disanalogies. But first, with respect to the Establishment Clause, essentially on the anniversary, what would have been the 50th anniversary of Roe versus Wade, a Missouri complaint was filed arguing that a Missouri abortion law violated separation of church and state because the law explicitly was enacted saying the Missouri legislature said it was the intention of the General Assembly of the state of Missouri to regulate abortion in recognition that Almighty God is the author of life. So many of these abortion statutes have explicitly been premised upon these religious purposes. And this lawsuit, among others, claims that that violates the separation of church and state, that a law that's based upon a religious purpose contradicts the Establishment Clause, would constitute an official establishment of religion. However, Supreme Court precedent, particularly in the Hyde Amendment cases, which many of you have been referring to back many years ago, the Supreme Court said that the mere fact that abortion funding bans coincide with the tenets of certain religion doesn't necessarily mean that they violate the Establishment Clause. However, longstanding precedent has suggested that laws should be based upon a secular purpose. You can imagine secular purposes for some of these bans, but many of them explicitly are invoking and predicated upon religious purposes. And so the question is whether this would violate the Establishment Clause. And this idea that law has to be based upon a secular purpose, not a religious purpose, dates to a case called Lemon against Kurtzman, a precedent which has been recently undermined. There are a lot of problems with the secular versus religious purpose requirement. First, how do you establish that a law is based upon a religious purpose? What if it has mixed motives? Some legislators enacted it for religious reasons and others for other reasons. And what about the futility? If you take a law that was enacted for religious reasons and strike it down, can the legislature simply reenact the law by keeping silent? There's also the question of whether striking down, some religious conservatives argue that striking down a law because it's enacted for a religious purpose would violate their freedom of to exercise their religion and to embody that in law. So the Establishment Clause argument is quite fraught. But the Supreme Court recently, on the Free Exercise Clause side, has considered anti-religious purposes as violating free exercise. And so some would suggest that if you applied that same sense of motivation to pro-religious purposes on the Establishment Clause side, then the failure to consider pro-religion purposes as Establishment Clause violations, while considering only anti-religious purposes on the Free Exercise Clause side, would reflect non-neutrality towards religion.
Do you think that the Supreme Court is neutral on the question of pro or against religion these days?
No.
No. After the Kennedy case last year involving the
It seems
prayer
clearly non-neutral.
Yeah, no, so free exercise wins over
Over Establishment
Yeah,
Clause.
okay, all right.
Yes.
So, any other thoughts on this question about trying to pick mixed motives? And what do you do if somebody put God in the statute? Strike the word God. Is it still constitutional?
Well, I think the Establishment Clause argument is a weaker one for all of these reasons, right? And also because Lemon seems, to have essentially been undermined. So it's not clear that the court is sticking to this secular purpose requirement, nor that it would strike down a law because of religious reasons. I think there's a much stronger argument, though, on the Free Exercise Clause side.
So why don't we turn to that? Go ahead. Barry, do you want to say something on the Establishment Clause?
I think the Establishment Clause is extremely strong. And I don't know that we should rely on the Supreme Court to be the arbiter of what's a strong argument or not. It was James Madison who said that we have a separation, a wall of separation between church and state so that the United States would not be soaked in blood as it was in Europe. We've seen what happens when church and state are united. It's a horror show. You get crusades, inquisitions, pogroms, and society is dragged down, and people like Galileo are threatened with torture. This is an extremely strong argument. We should not cede it. Just because the United States Supreme Court decides not to use it doesn't mean that it's not a good argument. It's one of the best ones.
You think it's going to win in the Florida Supreme Court, Barry?
I don't know what's going to happen in the Florida Supreme Court because we have a governor who wants to put "In God We Trust" in every school in the state. And I say, get rid of God. I say, in education we trust. That's what should be in every school. In wisdom we trust. What's going to happen there, I don't know. But I do know that these are very strong arguments that we should not concede.
There's certainly very strong political arguments. Radhika,
No,
let's move into the free exercise arguments and explain how they fit in particular, how they fit in with the recent cases that we saw arising during the pandemic.
Yes. Okay, so I actually agree with Barry on the Establishment Clause side, and some state courts might interpret their state constitutions to be more protective on the Establishment Clause side than the U.S. Supreme Court. So you could perhaps turn to state courts. But on the Free Exercise Clause side, the question there is under Employment Division against Smith, whether you've got a law that's neutral and of general applicability. And basically, the short story is that the Supreme Court recently has interpreted that those requirements, that a law be neutral and of general applicability in such a way as to really favor claims of religious liberty. So in Masterpiece Cake Shop, they found that a law was not neutral, but religiously biased, based upon just a few statements in the record at a lower, of the board in that case. And then, more pertinently, in the cases involving COVID restrictions during the pandemic on religious gatherings, the Supreme Court found that the fact of any secular exemption essentially would invalidate the lack of a religious exemption. Specifically, in Tundon against Newsom, the California case, the Supreme Court said government regulations are not neutral and generally applicable, and they therefore will trigger strict scrutiny under the Free Exercise Clause whenever they treat any comparable secular activity more favorably than religious exercise. So if people were allowed to go to grocery stores to shop for essential items, but they weren't allowed to gather together in private homes for religious reasons, then that was unconstitutional. It infringed upon their exercise of their free exercise of liberty. You couldn't have exceptions for life-sustaining activities, but not for soul-sustaining activities. So where does that put us with these abortion laws? Well, many abortion restrictions actually do contain exceptions. Exceptions for cases where the life of the pregnant person is at stake, or for health reasons, or in cases of rape or incest. So if any secular exemption requires a religious exemption, then in situations where parties of different faith who argue Jewish women in Kentucky who say that they want to engage in infertility treatments, but that they need the possibility of abortion in certain situations in case it's necessary to their health, and that their religion requires it. The fact that you'd have a secular exemption but not a religious exemption would constitute a law that's not neutral and of general applicability, and so it would violate their freedom to exercise their own religion.
Radhika, could you also talk a little bit about the vaccination exemption claims as well on religious grounds and how they would fit in, even if you take out the other exceptions of the cases you just talked about a second ago?
Yes. Well, so on the vaccine exemption cases, 3 justices have actually suggested that they think there need to be religious exemptions from vaccine mandates, Justices Thomas, Alito, and Gorsuch. Now, Amy Coney Barrett and Brett Kavanaugh haven't yet reached that conclusion, and some speculate that they're actually carefully staying away from the vaccine mandate issue because they see the parallels with abortion restrictions. And if they were to suggest that a religious exemption would be required in those circumstances, then one would similarly or might similarly be required.
But I think in most of the vaccination cases, there were religious exemptions as a matter of policy, not as a matter of constitutional law. So
Yes.
they didn't have to reach that issue.
They didn't
That
have to
certainly
reach
would
that
be
issue.
different. All
Yes.
right. I want to turn to Rabbi Silver now. I'll catch you in a second on the religious side. But I think we need to establish what is the argument that some religions, in his case, the Jewish faith, actually requires or at least permits women to have abortions as a religious matter, so we can get that as the background against which we can measure the other cases.
Sure. Thank you very much for having me at this wonderful panel and for putting together this convocation. Somehow I always manage to be seated at the far left. I'm not sure why that is. But,
You're the far right facing.
yeah, I know. My dad always taught me that in politics and religion, the heart is on the left, so I don't mind being here. I do want to share with you about Jewish law, because according to Jewish law, life begins at birth, not at conception. Okay, so, I mean, there's the argument about the rabbi, the priest, and the minister, and the priest says that it starts at conception, and the minister says it starts at 9 months, and the rabbi says, no, it starts when the last kid leaves home and goes to school, goes to college. That's when life begins. But if you look at Exodus 20:21, it says if two men are fighting and they injure a woman bystander and she is injured, then the person responsible pays a fine. It then says if she's pregnant and miscarries, the one responsible pays with a life, and it's because it's nefesh tachat nefesh, a life for a life. And then it says if she miscarries, then it's a fine. Okay, so it just says if the woman, I missed it, if the woman dies, the person responsible pays with his life. Nefesh tachat nefesh, a life for life. But if she miscarries, it's a fine. There's no clearer indication that according to the Torah, the fetus was not considered a human life, because it just said a life for a life, but the fetus dies and it's not a life. It's also in Genesis 2:7 when it says that human beings were created out of the clay, and then God breathed breath into them, and then they lived. Same thing with Ezekiel, dry bones. Breath, breathing, always equated with life. If you think about it, breathing and the heartbeat is an expansion and a contraction, just like the early universe expanded and contracted. And that's what we do as human beings with our lungs and our heart. That's associated with the onset of birth. So the whole thing about the Bible saying that life begins in conception is a misconception. The whole thing about abortion being banned in the Bible, there's a pregnant silence. It doesn't exist. There's no ban at all, which means the Bible is the first pro-choice document in the history of the Western world. There's absolutely no ban against it. And to call a fetus a pre-born baby is like calling you and me a pre-dead corpse. It's like calling an acorn an oak tree, an egg is a chicken, or arresting someone for arson who burns down the blueprints to a house. It's irrational, and it should be fought against, and it's a violation of Jewish law. It criminalizes Jewish law, as well as the law of everybody else in the country other than fundamentalist Christians and some Catholics.
So is there anything in the Jewish tradition that either requires, as a religious matter, or permits, as a religious matter, a woman to have an abortion when she believes?
Absolutely.
All right, you want to tell us that, too?
And you know, they say the only thing two Jews can agree on is how much the third should give to charity. Well, I'm going to tell you something interesting. That almost all the Jews across the board, Reform, Conservative, Orthodontists, everybody, they all agree on one thing, that life begins at birth. The greatest icon of Orthodoxy, Maimonides, who was also a physician, said, "Ubal yelech imo." The fetus is part of the mother. The fetus is always considered part of the mother. And if you have a choice between the fetus and the mother's life wins every single time. Even above if it's just a matter of her emotional health or her physical health, the fetus wins. The fetus that the mother's life wins. Trying to get a lot of stuff out quickly. The mother's life always wins because she's a life and the fetus a potential life. The fetus that we're interested in as Jews are the millions and billions of people in the world who are saying, feed us, feed us. We don't have enough food. We don't have enough resources. We're in an overcrowded world. We should not be forcing women to bring children into an overcrowded world. And it's also, it's chutzpah, to use a legal term, it's chutzpah for fundamentalist Christians to take Jewish scripture, distort it beyond recognition, and then force it back on the Jewish people and say, now this is the law of the land. Now you have to follow our law.
Adam,
We should
and
not
then,
be doing that. We wrote the Bible. We read it in the original. We know what it says. We don't need them telling us what to do. We don't need them telling Muslims what to do, or Hindus what to do, or atheists what to do.
Adam, and then Radhika.
Yeah, hi, and thank you again for having me. You know, I think our people would say that Rabbi Silver has good shtick. It makes for good polemic, and I certainly agree and am sympathetic to all of it. But I also believe deeply in rule of law. And what concerns me about this line of argument is that while it might be convenient in this particular circumstance, it very quickly leads to a situation where one can become a law unto themselves. Which is something that the Supreme Court cautioned against some 150 odd years ago. And I think that when, in my experience, and I represent religious organizations as well, when we have cases that involve their expression, I feel most comfortable making arguments based on efforts by states to discriminate against their exercise when there's differential treatment. I think that maybe I'd be interested to hear whether that's something that Rabbi Silver has explored, but I do worry that some of this argument could lead to a dangerous place where folks are seeking exemptions from civil rights statutes and so on. Now, I want to make two quick comments. It was the Masterpiece Cake Shop was mentioned before. That's an example of a case. That was a case involving a civil rights statute in Colorado. An interesting thing about that case, though, and they didn't quite reach the merits in that case. It was kind of tossed because they found animus in the Civil Rights Commission in Colorado. They're getting a replay of that now in a case called 303 Creative. And so we'll see what happens there. But with respect to the COVID cases, something that's been interesting to me is that I think, as Professor was saying a moment ago, these cases were decided based on the way they were overbroad. They weren't tailored well, right? So you were taking two likes in a way, and you were saying some people could gather, but some people couldn't. And there was a sense in which there was secular gatherings were permissible, but religious gatherings weren't. So again, there's a narrower way to make these kinds of arguments that have more of a grounding in treating likes differently that I think is persuasive and probably effective and good policy and good law in the long run. But I appreciate the fire and fury, and I have to work some of these proof texts into my own practice. But I like where it comes from, but I worry where it leads.
On those notes, I think that neutral principles are what we all try to believe in, and the fear here, I think, is that the Supreme Court won't be neutral in applying neutral principles to these religion cases. And so if you look to the law and the recent precedents, it would seem that the way in which they've expansively been willing to recognize claims of religious liberty on the part of fundamentalists and conservative religious believers who say that laws abridge their freedom of religion and their required religious exemptions from public accommodations laws in Masterpiece Cake Shop, or in Fulton, the Catholic Social Services gets an exemption if other exemptions exist from the public accommodations laws that require them to not discriminate against same-sex couples, then you would think that the same religious liberty claims should prevail here. But I am not so optimistic, and I think the court would be able to, or would try to draw certain distinctions. It might suggest that these religious believers, the Jewish women in Kentucky or in Florida, the synagogues, who say that their religion, they might argue that their religion permits but does not require them to engage in abortion, and that there's differences between laws that prevent you from doing things that are required by your religion versus laws that prevent you from doing things that are merely authorized or permitted. And they might also draw distinctions between laws that force people to do things that violate their religion versus laws that prevent people from doing things that are consistent with their religion. Now, I think the COVID cases actually stand for the latter proposition. So unlike a vaccine mandate, they might say a vaccine mandate imposes a vaccine upon somebody which contradicts their religion. But here, laws prohibiting abortion merely stop people from doing something that's permitted or authorized but not required by their religion. They might try to draw distinctions of those.
So do you think, I think in Masterpiece case in 303 and in the other religion cases, there was no claim that the person's religion required them not to serve gays or other people. So on that, just let me finish.
Yes.
On that, if they have a sincere religious belief that that they have to prefer the life of the mother as opposed to the life of the fetus, that ought to be enough if you think they're going to treat them equally.
I do want to comment on that, because in Judaism, it is not just that the woman's entitled. She is required to have an abortion to save her life. She cannot martyr herself. And these laws criminalize Judaism, which is part of this pandemic of anti-Semitism. Criminalizing the practice of Judaism is the first step towards a world in which you have white nationalists trying to take over the government and the laws and criminalizing the Jewish belief. You are required to do it. I also want to just take issue in a friendly way with what Adam said. He's saying, well, this would be terrible because the woman would be a law unto herself. Right on. She should be a law unto herself.
But every person, Rabbi, every person would be a law unto
All right,
herself.
time out.
No. Not every
I'm the
person.
moderator, not the referee. Okay.
No, not every
We
person.
promised free speech. Now freedom of
not
religion.
every person.
All right, please. All right, Laura, all right.
The woman is the one who puts her
no.
life at risk.
Push his button, okay? We want to shift to freedom of speech. And I'll tell you why it's important, because in the 303 case that's up before the Supreme Court now on the person who won't put up the website for same-sex couples, the petition, the request to the court was on both freedom of religion grounds and freedom of speech grounds. And the court said, we don't want to hear about the freedom of religion grounds. We only want to hear about the freedom of speech grounds. And this is interesting because in many ways, it's a wider notion. That is, you have a justification because you want to speak, not about the subject you want to speak religion, but for any reason that you want to have it at all. So potentially the free speech is even broader. But we're looking at the opposite side here, that is the interference with free speech. And Laura's going to talk to us about what she fears as a genetic counselor some of these abortion laws are going to have on her work.
Yeah, I'm a genetic counselor, and a fun thing about my profession is we spend a lot of time explaining what we are, which I'm not going to do fully today, but I'll talk a little bit about the role of genetic counseling with regard to in the prenatal setting and with regard to abortion specifically. And in an optimal world, which is not the one that we have actually, that would come up very early on in discussions because really a pregnant person can't make any good decision about what type of testing they want on themselves or their fetus without knowing what they're going to do with it. And so you'd have to have that discussion early on, like how are you going to use this if you want to have it? But in fact, that often doesn't happen. And really, to our purposes here today, significant that genetic counselors are very involved with people when a problem arises in a pregnancy. And these are different abortion discussions than really what we've been talking about for the last day and a half, because these are, for the most part, very much wanted pregnancies. They're things that happen later on. It is extremely rare to get diagnostic information in the first trimester. There is an inverse relationship between certainty and time, which is to say that while the clock's always ticking in a prenatal setting, the farther along in the pregnancy you go, the more certain the information you get your hands on are. And these discussions, though in the newspaper you may hear stories about somebody's like, you know, oh, they had to carry a child and that fetus and that was going to be born, there was no chance of life. In fact, uncertainty is the rule in the prenatal setting, and that's the exception. We're usually telling people, we're concerned about this, we can't exactly tell you how this is going to express itself, right? So you have tons of uncertainty, usually wanted pregnancies, late in pregnancy. These are, in other words, incredibly difficult situations for the prospective parents, making really, really hard decisions. And the genetic counselor is the person who's going to really take time to listen to them, to hold the discussions, to sort of work out with them what they want to do and how to do it. So it's a hand-holding role. And we take it very seriously. The genetic counselors, present company accepted, very nice people across the board, seriously. And so we help them with the decision. We also help them with logistics, right? So these questions about what we are allowed to talk about fundamentally affect our ability to do our job. And that's sad for everyone. But let me just say, we've known for all we talked about for days here, we know that we're not really talking about saying that, oh, no one's going to be able to get abortion. This whole issue is about some people are going to be able to get abortions and some people aren't. So if you want to talk about expanded access, and expanded access in this very difficult circumstance where something has gone wrong in the pregnancy, genetic counselors are the people that enable that to happen. Because across the board, if you have less, it's not just less literacy or less money or whatever, it's also like cultural support. If you don't have someone to talk to, if you don't have a community that supports your decision, all of these things, the genetic counselor is the person who can step in and help you, get out of state, get in touch with these wonderful abortion funds that are helping people. All of these things, they take a connection. And the more vulnerable, the younger person, the more complications there are in their life, the more they need that counselor. So that their person is really, you can see them as the person that's expanding access to abortion. All right, that's
To
my
be
thought.
clear, to be clear, you lay out the options for them as part of your responsibility as a genetic counselor?
Yeah, sure, absolutely.
Okay,
I mean, it's not like they don't think of this. Like, this is a dialogue, right? Like, you're in a conversation with them. The conversation is probably going to be more like, well, how survivable is this? What are the chances? What is my child going to look like? How severe are these effects going to be? Are they going to be born in pain? I mean, these are the questions that they're working through. They know there's such a thing as abortion. Like, it's not like,
Well,
yeah.
I mean, what time and where and how far along are they and when will they know something more? That's part of your responsibility to give them the full layout of the land.
Yeah, absolutely. And even, very early on, you might catch something on an ultrasound fairly early on. And whether or not that person wants there to be termination on the table is a part of how you act from there on in, right? So do you say, like, well, let's wait a few weeks and then go back and look, because we'll have, if they're not interested in termination, you can do that. We'll have better information in a few weeks. It is terrible practice if this person is very interested in ending the pregnancy to say, let's wait a few weeks and we'll go back and we'll see, right? Now you're talking about what, a 17-week abortion instead of 14-week abortion? This is not insignificant differences, not in any way, not in where they can go, not in how much they cost, not in how damaging they are.
I just want to add one thing just to sort of emphasize why we're having this specific conversation, which is that there have been proposed laws, model laws, to restrict the ability to aid and abet abortions, which can include talking about abortion as an option. And so one reason that we wanted to have a genetic counselor on the panel was because the doctors are doing the abortions and they're prohibited from the act. But we're talking now about the speech, and that's why it's so important to understand the role of the genetic counselor.
So I was doing some research with students of mine in 2021, where we were going to be having interviews with genetic counselors that work in prenatal roles in restrictive states. And SB8 happened in Texas. And so we turned into a sort of a natural experiment where about half of the people we were talking to were working under SB8 in Texas, and about half of them were working under a variety of sort of allowable before Dobbs restrictions, right? And what we found was the big difference in what was effectively a post-Dobbs universe, even though it happened before then, was extreme concern about the legal jeopardy coming for themselves and being pushed from their institutions. I told you in the intro, I was a podcaster the very first day that SB8 went into effect. I phoned a friend of mine who is a prenatal counselor, a very senior person, very outspoken person in Texas, and said, come on the show, talk about genetic counseling, prenatal genetic counseling in Texas under SB8. And she said, my institution says I cannot say the word abortion aloud in public. So if you, it's interesting because you will hear that there's not very many of these cases, and it's true that there's not very many of these cases, but is it affecting people? 100%, because it's affecting their concerns, and their institutions are leaning on them. And in fact, what we found was the people were self-censoring beyond what the law calls for. And I think that's true across the board, that one of the problems we have, and doctors have gotten a lot of and then some totally deserved in some cases the last couple of days, but you lawyer people, the people are it's my job actually to know all these different laws, but if you have a lot to keep up when working in genetics and prenatal care. It is not actually your job to keep up on every change in the law, but now it is, right? That is very, very difficult thing to add to your job. And people are naturally they don't really know what they can say and what they can't say. And so they are self-censoring, and I think across the board in medicine, self-censoring is magnifying the impact of laws or putting them into place before they actually happen. And I think that's something we really need to be communicating well to the medical people of what they are allowed to do and what they aren't allowed to do. And in that vein, we had The counselors who told us that they could do the most, that they were comfortable doing the most, had good institutional support and they were told, we will support you if you're drawn into court, we have your back. The ones who had no support were self-censoring pretty much the most, but also, I made a comment like that in public, and somebody who's a genetic counselor in Georgia came up to me and said, we had a doctor trying to figure out, he had concerns about how he could define a life-threatening condition in his patient who was pregnant, and he asked the legal department for help in defining it, and the legal department, and I quote, said, "It is easier to defend you against malpractice." In case you didn't understand what that means, that's your legal department saying, let her die. That's an easier case for us to take, we know how to do it, than to explain what you're establishing as a exception. So we're going to talk a little bit more about exceptions later, but I just put that out there.
Yeah, so, I mean, we're talking now about the self-censoring and the way that the SBA talks about aiding and abetting and sort of that vagueness so that then counselors think, I can't say anything. But there also have been proposed laws to literally say you cannot talk about abortion. And so one of the questions is, well, what would the Supreme Court do with this? And we don't have a lot of Supreme Court jurisprudence with respect to restrictions of healthcare providers' speech or regulation of it. We have sort of three main cases. So the first one is a case involving a law, or Title X funding really, where it said there was a speech restriction for providers who were getting Title X family planning funds, saying that you may not counsel, refer, or advocate for abortion as part of your funding. Right, so that's restricting speech. And the court said, well, you know, that's okay because it's tied to encouraging family planning and we're not suppressing a dangerous idea. And besides, you're just prohibiting the grantees, or you're just ensuring that they engage in a particular project for which there was funding. But the case made very clear that it was all right for the government to have some kind of speech regulation that promoted family birth and discouraged abortion. And so then a year later, Planned Parenthood versus Casey, which upheld Roe and changed the standard of review, but there was a speech aspect of it because there was a mandated disclosure provision. Physicians were supposed to inform patients about the risks of abortion, the risks of pregnancy, the gestational age, and also make sure that they got information about non-medical information like child support and adoption. And there the court said, yeah, that's not really a problem as long as the information is truthful and not misleading. And while it mostly focused on the undue burden test, there was a very short little description about the First Amendment implications. They said, yeah, this does affect physician speech, but it's really just part of the practice of medicine. So it's really not that big a deal. And it also emphasized that, again, okay for the state to push for a particular kind of outcome, not abortion, even if that pressures women, as long as it's not an undue burden. So a lot of people sort of took those few sentences and said, well, what does this really mean? Does it mean that physician speech isn't really very well protected? Or does it mean that it is really well protected? We talk about the standard of review, basically how protected is the speech? So then in 2018, there was another mandated, so again, compelled disclosure, where doctors in California or licensed clinics that provided care for pregnant people were supposed to provide information about free and low-cost funding for family planning, prenatal care, and abortion, and all those words. And so everybody sort of thought, well, okay, if the state can require you to talk about child support and adoption, which isn't even healthcare, surely licensed clinics should be allowed to be told that they have to tell you you have all these options for reproductive care. But the court, surprisingly, was not consistent here and said, no, Casey was okay, but this is a violation of the First Amendment. Now, the court realized that there was a potential inconsistency here, so it made a really tortured attempt to distinguish the two. And it said, well, the mandate in Casey was regulating conduct, the abortion, and the speech regulation was just, incidental. It incidentally involved speech. But in the NIFLA case, the compelled speech was regulating speech as speech, and that's really problematic. And so we have to review that really carefully. There were a few other things that were going on. The court was concerned that the law was addressing crisis pregnancy centers, which most of you know are trying to discourage people from having abortions and that are often religiously motivated groups. And the court also pointed out, there have been earlier cases regulating the speech of other professionals like lawyers. And in those cases, you can compel the speech as long as the information is truthful, not misleading, and not controversial. But Justice Thomas, writing from the majority, said, in this case, they're mandating the word abortion, and that is anything but uncontroversial. The court also spent a lot of time talking about the putative dangers of compelling speech and sort of suppressing minorities. Who are the minorities that the court was concerned about suppressing? Religious groups, right? The undercurrent of this case that was really supposed to be about speech was really about this concern that these crisis pregnancy centers were being made to say something that went against their religion and therefore was harming that particular belief system. And so, I think that the speech restriction should be problematic under the First Amendment, but I have no faith that the court is going to be consistent, just as was being discussed with respect to religious expression. I think the court will be entirely inconsistent.
Sonia, are you talking about the mandated speech or the limits on?
Either, because the court really was almost more stringent with the compelled speech than with
I
restricted
think
speech.
they are more stringent with the compelled speech. Adam, and then Laura.
Oh, okay, I just wanted to ask Sonia a question. I'm surprised you didn't discuss the script laws. Script laws. So like there are, I'm going to get
Yeah.
it wrong there's probably people in the audience that know 8, 10
Yeah.
states where you're compelled to tell somebody that
Right.
an abortion could cause breast cancer.
Yeah, that's what I'm talking about. All these informed consent mandates. In Casey, the court said that general idea was okay. Now, that court hasn't examined those specific ones where they're arguably misleading and not truthful. But if they are, right, if the court thinks the data supports it, then those would be okay.
Yeah, I think that, so first of all, Laura, it's so horrible to hear what's happening on the ground. And you see it in Supreme Court cases. They talk about how when you enact a vague and overbroad law like this, people steer wide of the unlawful zone. And that sounds like it's exactly what's happening. And it's just hard to hear that happening in real life. What's interesting here is I think that this is the distinction that came up just at the end of this conversation, is that there's doctrinally a difference between compelling speech and prohibiting speech. And compelling speech is still considered a constitutional problem. It's content-based because you're making someone say something that they would not otherwise say. But the court has sort of created all of these different exceptions for consumer protection generally, but also professional speech. And for that reason, the ability to compel speech in these kinds of settings might be easier than they can to restrict speech. The challenge, I think, is that where these new laws and the model law and others like it come in, is that what they're doing is they're making speech integral to criminal conduct. And so if you think about the speech that is protected by the First Amendment, we know there are certain things that aren't protected. Right, certain kinds of obscenity, defamation, incitement. There's another category for speech which is integral to criminal conduct. So you could think of an example of two companies conspiring to violate the antitrust laws, right, to fix prices. Well, they do that by speaking or communicating to one another. That speech isn't protected by the First Amendment because it's integral in this conspiracy, which is a crime. Now that we have Dobbs, and states have now passed or have snapback laws that allowed certain types of abortion or all types of abortion to be criminalized, speech which aids or abets, and I use those words carefully, I'll come back to them in a minute, but that aids or abets that conduct is now criminal. And that's sort of the world in which folks like Laura are operating. The challenge, or rather the limitation, what ought to be a limitation, is that some of these laws are much broader than aiding and abetting. So aiding and abetting in legal terms is a very specific meaning. It means that you essentially want to help a specific person do a specific thing. The Supreme Court this week heard an argument in a case about providing assistance to terrorism, which, if you listen to the argument, kind of touched on the federal version of aiding and abetting. But these laws, and I have the language of the model law in front of me, use words like knowingly or intentionally operating an internet service purposefully directed to a pregnant woman that provides information that is reasonably likely to be used to facilitate an illegal abortion. That encompasses anything from what Laura does to what folks who might be protesting some of these laws might be doing out on the streets, carrying signs. These are core political speech acts, and these laws would prescribe it. We haven't talked yet about some of the cases like Bigelow v. Virginia, which was a case about discussing abortion in New York when it was illegal in Virginia. There was an advertisement in the newspaper that said, "Come to New York. We have abortions here." But in cases like that case, for example, didn't have an overbreadth challenge. And that's a tool that I think, as we switch to Q&A, a tool that I think will be in the toolkit for folks who are looking to challenge these laws or resist criminal penalties under them, is their vagueness and their overbreadth.
I just want to share that in Florida, we have a law that says if you actively participate in an illegal abortion, you can be tossed into jail. What I'm telling you right now could put me in jail. Because if someone listens to me in Florida, or when I preach from the pulpit, and they go out and have an abortion, I've now actively participated. And it's vague, and it's chilling, and it criminalizes speech, not just for healthcare workers, but for religious people. It's a double whammy of religion and speech. And what they tell you is you have to tell the woman all these different problems with abortion. They never say you have to tell the woman that she's far more likely to die from childbirth than abortion. This is not education. This is religious propaganda that is being told as the law of the state, and it should be illegal.
Time for questions.
Hi. Hi, my name is Dr. Julie Bindeman. I'm a psychologist. So Laura, really appreciate what you're talking about because these same kinds of things are impacting my practice. Wanted to get a sense of some laws. Okay, wanted to get a sense of some of the laws that are already on the book that are okay, like sidewalk counselors. So I'm so curious. I know in Maryland that was something that was challenged and ended up not going as far as we were hoping. That was trying to prohibit sidewalk counseling, quote unquote, given by non-licensed professionals, which goes against all of our boards in terms of who can practice psychology or social work or counseling. And sort of, I don't have a quite formulation of this question, but looking at that and the juxtaposition too of actual exceptions, which are not really exceptions. So I know they talk about exceptions for fetal anomalies. They talk about here are the ones that are okay. But when people like the woman in Florida, this Washington Post story that was last week, tried to get an abortion for Potter syndrome, which should have been one of the exceptions, she was unable to obtain care because the physicians would not give her care. So it's this juxtaposition too of what is considered speech, who can do that speech, even though we have laws around who is allowed to do things like counseling. So again, it's not really a question, but just these concepts that I'm circling in my mind.
Yeah. So I'm going to speak to the exceptions bit. I don't really, we don't really have sidewalk genetic counselors that I know of as an issue. But certainly they wouldn't have licensure, so.
Oh, okay, I'm sorry.
The exceptions, the exceptions that exist are a huge problem, very much akin to the life of the mother exceptions, which is that they generally require, and there's now nothing in court to sort of measure out how are they going to be adjudicated, right? Like so they require you to say, this fetus will not survive. And there's no explanation of what does survive mean. Like if you survive 30 seconds, is that surviving? That fetus that had agenesis of the kidneys, they would have no lungs. That was actually the functional problem. You can survive that. But so they would immediately born and asphyxiate, right? A very unpleasant, painful death. And there's absolutely zero chance, but that's really rare. Like most of the time, like I said, we could say 95% of the time, this child is not gonna live more than a year. Is that enough? We don't know. And really the answer has very often been like, no, just no to any of these exceptions because we can't define them. And I I have talked to a lot of my sort of former students that are working, like, what are you doing? And some of them tell me things like, well, in our practice, we say, if 2 doctors agree that this is lethal, we say yes, but we're not writing it down anywhere or telling anybody or explaining anybody our process because they're afraid to go out. You know, there's a lot of fear.
So this is the vagueness problem that some of us have alluded to before. But the other thing I want to say is, and Laura mentioned it before, is if you're a doctor or a genetic counselor and you work in an institution, if the final word is your institution's word, and whether you think it comes within the law or not, doesn't matter because the institution tells you no, and the institutions are by and large much more self-protecting than people down the line are. The answer is going to be no. I question.
Adam, I'm wondering if you can talk about the May Day suit and the
Yeah.
the broad implications of that for free speech around abortion.
Yeah, thank you. That's ostensibly the reason I'm here, so I'm glad you asked the question. So I represent an organization called Mayday Health, which some of you might be familiar with. And Mayday is a nonprofit organization that was founded in the wake of the Dobbs decision, or really the leak of the Dobbs decision. And what they do is to go into prohibition states and provide information. They're an educational nonprofit. They provide no services. They sell nothing. They are fully supported by donations. And they have been, for example, most notably, they went into Mississippi, Jackson, Mississippi, which is where the Dobbs case came from, and started by putting billboards up saying, pregnant, ? You have a choice. Go to mayday.health. And this caught the attention of the Attorney General in Mississippi, and the Mississippi Attorney General sent a cease and desist letter and, started making some investigative demands, and we responded to that by saying that this is speech. The advertisement doesn't even just poses a question and says, check out our website. And then we challenged the jurisdiction of the Mississippi Attorney General to issue that subpoena, and it kind of took us ball and went home. But what we are encountering is that since that time, Mayday is now they're on Instagram, they're on TikTok, they're everywhere. They're in states. They're really clever guerrilla marketers, and so if there's a bit in the news, like at the University of Idaho, there was an issue where at Idaho, the students were no longer being counseled to seek reproductive health treatments, including abortion, because Idaho had passed this ridiculous law that not only criminalized abortion, but certain types of prophylaxis. And so they sent in a noise truck to kind of go around and broadcast this message, and pissed off some people. But the kinds of things that we deal with, the kinds of things that we counsel them on, are the kinds of things that we were talking about a moment ago when we were discussing what does it mean to aid and abet, right? And it's a fine line, but generally speaking, we feel confident in the position that what Mayday is doing is fully protected. It's informational speech. It's not commercial. The Bigelow v. Virginia case that we talked about was an advertisement by doctors. There are some distinctions. Bigelow, at the time, was saying, come to New York where abortion is legal to have this procedure. It's not clear and we're careful to not go too far in the message that we put out there, but it's not clear in Mayday's messaging whether they're telling you to do something or telling you can do something in the state in which you're hearing the message, or whether you can go somewhere else. And they're not speaking specifically to any given person. But we feel like, given the nature of what they're doing, it's providing an important service. It's giving people information specifically about the ability to obtain abortion pills, and saying that those are available in all 50 states, which is a true statement, at least until we see what happens with the FDA lawsuit.
So
But
if you're talking
yeah.
about the internet, there's an additional law school
Yes.
nerdy question about whether individual states can regulate the internet by putting up themselves a barrier saying you cannot do this.
Yeah.
Quite different from the billboards or newspaper ads in the state. So those of us who are dormant commerce
Yes.
clause nerds.
A quick response on that, because I am such a nerd, and I have a couple of cases about that exact issue right now. Okay, yeah, send me a brief. Well, the early internet cases suggest that states can't regulate internet speech. States following in the late 90s, the federal government passed an anti-pornography law, then a number of states passed their own anti-pornography laws. The federal ban was struck down, the states thought they could keep theirs up. One of the reasons that the state bans were struck down is because they were regulating speech across state lines, internet speech across state lines. Now, in the years since then, courts have said things like, well, you could geo-target now. These laws aren't necessarily Commerce Clause problems, or Commerce Clause, again, the issue there is, are you regulating outside of state lines? Courts have said, well, you have technology now where you could sort of target and control your message. We have arguments that the practical effect, though, is for many of these companies to regulate out beyond state lines. There are some law professors who disagree, and Eugene Volokh has an article about this coming out soon. But that's another problem with some of these individual state laws, is that they're trying to regulate speech in California or in Massachusetts or in New York.
Yeah, I just wanted to add one thing, which I think was sort of implicit when you said, but just to sort of underscore for the audience. So with the billboards, where you're advertising how you might be able to access abortion pills, which if you used in a state that banned it could be a problem. So then the question is, can you ban speech that leads to criminal action, sort of tied to what you'd said earlier? And the issue is, there's a famous case that says that it has to be that it's imminent, that your behavior is likely to incite this unlawful action in an imminent sense. And so I think your point about the billboards is that it's not, I mean, maybe somebody will do something illegal, but there's no guarantee it's imminent.
That's right, but the other thing, though, is the integral to criminal conduct part is that what we're concerned of, I'm less worried about the case that Sonia was talking about. It's called Brandenburg. But I'm less worried about the incitement of some imminent criminal act. I'm more worried about the state saying, you've aided and abetted a violation.
So there's also an earlier case called Pittsburgh Press, which the Supreme Court said they had a law that said you couldn't have advertisements that said males only for the particular positions. And the court said, despite the fact that it's speech, it could be struck down because the conduct itself was illegal. That is to say, the restriction to only have males. So the fact that you were engaging it through speech didn't save it. So we've got that case to worry about as well. So there's a lot of other things. We got a couple more, any more questions? We got some more questions here? We can't possibly answer all your questions.
one
Over there, yes.
Hi, yeah, thank you all so much for this enlightening conversation. My question is less technical, and I'm gonna give some quick context. So prior to moving to DC, I've been living in Alabama for most of the last 8 years. And so I just think a lot of the conversations around religion with a specific emphasis on evangelicalism are just completely unserious. I think being in Alabama, religion is a cover for white supremacy and cis heteropatriarchy. And so I think I'm trying to conceptualize how to even think about religion and the legitimacy of religion as we're having these conversations, because of the ways that it's weaponized in these very specific racial ways, if that makes sense.
If I could tackle that one as a rabbi and a lawyer. The Bible describes women as an afterthought. God created Adam, and then he created Eve to keep him company, to do his dishes and to do his work. And then she introduced sin into the world with the apple. These laws are based on myth. And because of that, these laws and these religions themselves are myth-led, myth-guided. They're myth-informed people, and they're misogynistic. And if you do not follow a logical path, your religion will be pathological. These religions are anti-woman, and as a rabbi and as a man, I apologize deeply for the role that religion has played in suppressing women all these years. Women are a law unto themselves because it's their body, they risk their lives, and these laws restrict and prohibit and discriminate against women, and it's about time that religion atone for the sins of the past, and men do as well, and allow women who risk their lives to give birth to determine for themselves when they will do so and when not.
I share many of your fears about religion. At the same time, I feel like, and I live in a bubble, Berkeley, California.
No.
But I do feel like we have to treat people of religion as people of good faith. That if we say that all of them are tarnished, kind of with this brush, that's it feels like it's not fully fair. So I do feel that there are people of good faith who actually hold these beliefs deeply. And if we're going to ask for, fairness with respect to our arguments and our beliefs, then we should try to provide the same kind of good faith, opportunity to others.
Anyone else? Final word? Anyone?
I mean, on this question, I agree with everything you just said. I represent the Universal Life Church, which in a lot of ways was founded because they wanted to create a safe space for people who wanted to have a religious experience that were excluded from other denominations. And those folks, they feel deeply about what they call their faith, and who am I to question that? But I share everything that you identify as what might be the fig leaf of religion coming up in these contexts.
I just need to respond. They say that good people do good things and bad people do bad things, but to get good people to do bad things takes religion. Religion could make us good people or bad. They are people of good faith, but they're misguided, and they're misinformed, and they're destroying what's left of our country, just like the people who did the Inquisitions and the Crusades. They were people of good faith, but we need to stand up to them because they're taking our country in a path that we've seen before. It's a very dangerous path.
I think that's it. Thank you very much.
So we have only a 10-minute break for our next panel, which is going to be the impact of Dobbs beyond abortion. So we'll start at 2:50. Or, yeah, 2:50.
Like, sometimes we're not well represented.